Right. I'd like to welcome everybody here to class this evening. We're going to get started with our set of cases for this evening. What we're going to be covering is the statute of frauds. Obviously, the statute of frauds was a subject that was covered in contracts, but we're going to go into it in far more detail this evening and how it relates in real property cases and its application there. So, Mr. Troncalli, Mark, you are our first student up this evening with the case of Burns versus McCormick. Can you first tell us about the statute of frauds? What exactly is the statute of frauds and when is it applicable?
Hi, Professor. Good evening. Statutes of frauds are applicable in contracts that take place of performance over a year. If the value, I believe, is over $500, if there's a co-signer, or in the transfer of land. Those would be the scenarios.
And what is the important thing about these contracts that are covered by the statute of frauds in particular?
You mean oral, the oral part of them? It's an oral contract?
Correct. That they've got to be in writing. These are contracts that must be in writing to be enforceable. And so if it's a contract that can't be performed in a year or for goods for more than $500, they're covered. But in our case, what we're specifically interested in this evening is the transfer of property, the transfer of land. And so that's what we're going to be looking at. Can you tell us about the case, Mark, Burns versus McCormick?
Sure. This is an older case. It's a case from 1922. So the nature of the case is it's actually an appeal from a decision to deny specific performance over what was alleged to be an oral contract for the sale of land. Basically what happened was Halsey told the Burns were the plaintiffs, Halsey was the defendants, or actually Halsey's representatives, that if he would board and care for him during his life, that he would in turn give him his house and all of his furniture at his death. He unfortunately died and did not have a will or a deed or any record of this transaction. And the Burns sued for specific performance of what they felt was an oral contract. And the other parties that were interested. And the McCormick was successful at the trial court because the trial court denied specific performance, and then the Burns appealed. And basically the issue of the case circulates around our acts of part performance solely and unequivocally referable to a contract for the sale of land. And the Judge Cordoza held that no, actually acts of part performance are not solely and unequivocally referable to a contract for the sale of land. And he basically said that in general, statutes of fraud would require a written contract for the conveyance of real property. And in this situation, the performance wasn't unequivocally referable in the agreement. And not every act of part performance would count for a specific performance. And the judge said, you know, it could have been that there was an exchange of rent for the services or a variety of different ways that the service could have been exchanged, but it wasn't unequivocally for the transfer of land. So because of that, the statutes of fraud was not satisfied, and the higher court affirmed the lower court's decision.
Okay. It seems pretty clear-cut. Now, didn't the Burns, it's a couple, take care of him for 5 or 6 months and give up a business? Doesn't that show that there's a contract?
And yeah, the court kind of went through that because they did give their time, the services, but it was more of a service type of restitution that they should have been looking for. The court kind of reasoned through, rather than the sale of real property or land here. So the court basically agreed that they did offer some services, but the type of restitution that they were seeking didn't seem to be proper.
Yeah, it seems like what they're going to get here is compensated for their services rendered, whether that's, as the judge talked about, housekeeping or any other types of services they provided. Well, what about the business that they gave up? Do you actually, I know I was probably one of the few people, do you know what a draying business is?
I'm sorry, I don't, Professor. What is it?
Oh, okay. Elizabeth.
A draying business is actually a truck driving business. It's a truck without sides on it that I looked this up, and it's especially good for extremely heavy loads. So he was basically a truck driver.
Yeah, he gave up his truck driving business in order to take care of this older gentleman. But again, the courts have said what he's going to be able to get here is restitution damages. And you focused in on the key word, this unequivocal nature of the reliance has to have occurred in order to get into an equitable remedy. At least that's the way the courts looked at it back in 1920-something. And we're going to see the evolution of this rule of law over the next two cases, because we're going to get very different outcomes as we move 60, 70 years into the future. Any other questions or comments about the case? Elizabeth?
Yeah, Professor, actually, I thought it was really interesting. Seeing that this case was from 1922, some of the, and forgive me if this seems harsh, sexist language of the time, and the notes go on to talk about that more extensively and the difference in real property as it was seen by men and women. But I thought it was very interesting how, in this case, the famous Cardozo calls the woman the housekeeper and refers to her services for exchange as housekeeping, but the man he refers to as buying the house. And it's interesting how that has unfolded over time and changed, thank goodness. But I thought that was really stuck out in the case.
Yeah, it was interesting language, wasn't it? I saw it as well, and then I noticed it was brought up in the notes. So yeah. And that's sort of the evolution of our judicial system as well. The language develops, but it's also a reflection of the time. The men bought stuff, and that wasn't necessarily true for women. And so yes, we have seen a great evolution for women in the workplace and in purchasing property and things along those lines. Excellent. All right, well, let's move on to our next case, Hickey versus Green. And I believe, John Vander, you are going to tell us about that case.
I am. Thank you, Professor. This is actually an interesting case, and the reason I think so is because I think we can relate to it even in contemporary times, where we believe we've completed a transaction, and later on we realize that that's not the case. So on to the case. This is a case from 1982. The plaintiffs at the time entered into an oral contract to purchase from the defendant, Green, a lot for $15,000. They gave them a check. They gave the defendant a deposit of $500 that she accepted. And on the back of the deposit check, he wrote the plaintiffs that they stipulated the check was a deposit for the lot subject to condition that a zoning variance was approved by the town. A few days after writing the check, the plaintiffs learned they would not need a zoning variance to build on the lot. So the payee at the time left the line of the check blank because they weren't entirely sure who it was going to be made to, whether it was going to be made to the seller or to her brother. So they decided to leave it blank with the understanding that the defendant at the time was going to fill in what she felt was appropriate. In reliance on their arrangements, the plaintiffs ultimately sold their house. They actually went through a few days later and listed the property. It was listed for 3 days, and just as quickly it sold. A few days after that, the defendant came back, told the plaintiffs she didn't want to sell their property. She didn't want to sell her property because she got a better deal. She got about $1,000 more. She got $16,000, and she wanted to back out of the contracts. They told her, the defendants told her, unfortunately, you can't do that. We sold our property. We're now in reliance on what we agreed on, and if we don't continue with this, there's going to be damages. So she refused. They even offered her the same $16,000, still refused. Out came the suit. Now, they filed for specific performance. Typically in real estate, that's one of the damages. That's one of the remedies is specific performance, so that they have to complete the sale. And the trial court, lower courts agreed with them. They essentially stated that, yeah, you guys entered into a contract and we need to complete the purchase of this house. Now the issue in here is whether a party's part performance in reliance on that oral contract to purchase the real property, does that make the contract enforceable? And the appeals court said, yeah, it does. The reliance of the plaintiffs on their oral contract with the defendant created an enforceable contract for the sale of real property. The case was remanded back to the trial court to amend the judgment to require conveyance of the property, to essentially have them sell the property, only on payment of the initial $15,000. So that's, in a nutshell, that's kind of what happened. Now, again, this is a situation where we can all kind of relate. We make a deal with a particular person, and in real estate, obviously, the statute of frauds holds up. We have to put it in writing, and in this particular situation, they felt that it was enough. Part performance was enough to complete the transaction.
So in 1922, detrimental reliance, Mr. and Mrs. Burns give up their truck driving business, is not sufficient for collateral estoppel and to create, to take it out of the statute of frauds. But in 1982, 60 years later, the court says that the Hickey's detrimental reliance of selling their house is sufficient to take it out of the statute of frauds because there's been this detrimental reliance. It completely overturns the earlier case. And so you can see over time the shifting values in society. Perhaps courts are better geared for things like this, but it really does completely overturn the last case. But there was something in particular, John, that when I was reading the case, I kept harping on. Isn't the check sufficient as a writing to take it out of the statute of frauds? Because we know it doesn't have to be a full-blown contract, but doesn't the check that Mr. Hickey wrote to Mrs. Green constitute a writing that proves that there was a contract?
That's a great point, Professor. And unfortunately, no, not in this case. And there's a couple of reasons for it. There's actually a few reasons. One, she never cashed the check. She simply just didn't cash it, so it was actually never completed. The terms, even on the check themselves, although they attempted to write some of them, they weren't sufficient enough to construe a contract. And that's kind of what the court looked at. And finally, they can't be used. The check can't be used against the signer. So in looking at these things, the courts realized that although there was some of the terms there, it wasn't sufficient. But the part performance from the plaintiff was sufficient enough to force specific performance.
Exactly. You can only use the writing that's not a contract against the signer. And Mr. Hickey's the one looking to enforce the contract, and he signed the check. If the check or the writing had been from Mrs. Green, then there might be something there to take it out of the statute of frauds. Good job, John. That was a good spot. All right. Any other questions or comments about this case? All right. And it really is a big case because we see it's a monumental shift in that the courts are willing to look at detrimental reliance to take cases out of the statute of frauds. Our next case is Gardner versus Gardner. Marcella, can you please tell us about that case?
Sure, Dean. This is about two brothers, Mark and James Gardner, who conveyed their interest in land to their brother Harry so that he could secure a loan. Harry was in debt to the Citizen State Bank of Oakland and needed a security and requested that the brothers do this. And his brothers did convey their interest in real estate to him by quitclaim deed, which did not mention the agreement to reconvey back. However, even after the loan was denied, he did not reconvey Mark and James' interest back to them, and they basically had to file an action to compel the reconveyance. So the issue is when a party partially performs under an oral agreement, will the statute of frauds bar the introduction of evidence of an oral contract? And the rule is when a party partially performs under an oral agreement, the statute of frauds will not be a valid defense. Oral evidence may be used to establish the agreement. And the court held no. A party who partially performs under an oral agreement may escape the impact of the statute of frauds and introduce evidence of the oral agreement. And here we know the brothers did perform. They conveyed their interest in the farmland to their brother Harry. And that act is sufficient to take the oral agreement from the operation of the statute of frauds. And the the trial court basically erred in refusing to admit the evidence of the alleged oral agreement.
All right. Thank you, Marcella. Exactly. In the case of Gardner versus Gardner, we've got a quitclaim deed. Two brothers and a sister quitclaimed their interest in the property over to a third brother. He's trying to secure a loan and fails in securing the loan, but he's going to take this opportunity to cheat his siblings out of their inheritance, of course. So he refuses to transfer the property back. But because the quitclaim transfer is in writing, any oral modification, any oral agreement relating to that is admissible under the parole evidence rule. We've got some type of writing. We know there was the contract for the sale of property, so we're going to allow in any other type of oral evidence that's reasonable that explains the contract out further. And so if the contract doesn't have to cover everything, now, would have it been better for the two brothers and the sister, to get it into the quitclaim transfer, or to get a contract saying after you get the loan, or if you don't get the loan, it gets transferred back? Of course. It may have avoided the whole lawsuit, but contracts aren't perfect. They don't have everything in them every time. And so under the parole evidence rule, we can bring in the oral modification that better tells us about what was intended with this quitclaim transfer of property. All right. Any questions, comments, or concerns relating to any of our cases dealing with the statute of frauds and the transfer of property? Yes, Elizabeth.
I actually have a question. When you look at the three cases, and I know that you sort of explained over time how the law has changed and grown so that the detrimental reliance and the par performance, the Green case basically overrode and overturned the Burns case. I'm wondering, is there any reason to it? In the Burns case, Mr. Halsey died, and there was no way for him to say, yeah, I made this agreement. But in the Green case, Green basically admitted that she did make this agreement, as well as the Gardner case. It even says that the brother basically admitted into evidence that he had made this agreement, although it was fishy and he kind of hemmed and hawed, it seems like, and wouldn't admit at all. But he did partially admit, it's even in the holding here, he partially admitted an agreement to recovery. So I'm wondering how much of that plays a role in this, if at all, in the way the law has changed or the way the cases came out.
I think it's an excellent point, Elizabeth. It's something that I hadn't really keyed into either. But clearly in the case, in the Burns case, the decedent isn't there to explain himself or to defend themselves in the lawsuit. I think if you were an arguing attorney and your scenario was closer to Burns than it was to Hickey, that you would argue that that's a distinguishable fact and therefore Burns would be the controlling case. I think you'd have a really good argument. You may be able to convince the court that they should be, you know, if you're representing the estate, that there's probably a lot more there. Whereas if there wasn't a decedent, you would then be looking at Hickey v. Green and Gardner versus Gardner as better precedent as far as what's going on. I think that's a really good point. And as you get out there in the real world and start working on cases, those are the types of things that you can cue in on and really exploit to your advantage to say, look, this case doesn't apply because we're not like Hickey versus Green 60 years later. We're still under that solid old rule because we've got a decedent here who's not in court and who can't defend himself and there's no writing. Whereas if the situation is different, you'll have to work with those facts. But there's always cases that can be found. There's always cases that you can argue. Excellent point, Elizabeth. Any other questions?
Professor, we can't hear.
What I was saying is, Elizabeth, that's a fantastic point. It's something that I hadn't even cued into, but that definitely that's something that you're going to want to argue, that if you were out there in the real world and had a case where you had a decedent and they're not there to defend themselves to say, yes, I made this agreement, no, I didn't make this agreement, that you would argue we're distinguishable from Hickey versus Green. We're like this solid old case of Burns that, you know, you shouldn't apply equitable estoppel. You shouldn't be looking at detrimental reliance. It's not in writing. The party is deceased and they're not here to defend themselves, and so therefore the transfer doesn't occur if you were representing an estate. Whereas if it were a different set of facts and it was closer to Hickey versus Green or a Gardner v. Gardner, then you're going to have to work around it there. But really, it's an excellent point, Elizabeth, something that I hadn't even cued into. And, you know, there's always cases out there. There's always cases that you can use to distinguish your set of facts when you're representing a client from the defendant or plaintiff's argument. And so if you can cue into things like Elizabeth just pointed out, you're always going to be able to distinguish cases. whether it's on the facts, how they're getting applied. The more research you do, the better you are at spotting things like that. You're going to be able to use that throughout your career. So good job, Elizabeth. Excellent. Any other questions, comments, or concerns? All right. We're now going to move on to misrepresentation and fraudulent non-disclosure.
They did not tell what he knew about the poor structure of the roof. Mrs. Davis specifically asked about watermarks on the ceiling, but Johnson told her that they were not watermarks and that the roof was in good working order. After the Davises paid a deposit to Johnson for the house, a rainstorm occurred, and Mrs. Davis entered the house to find water gushing in from the windows and ceiling. The Davises brought suit alleging breach of contract and fraudulent misrepresentation. The issue here is a home buyer entitled to a refund of the deposit when the seller knew but failed to disclose significant leakage problems in the house's roof. And the rule was where a seller of property knows a fact materially affecting the value or the desirability of the property that are not observable or known to the buyer, the seller has the duty to disclose these things to the buyer. And so the court held that the seller of the house was liable for failing to disclose material problems with the structure of the house that he was aware of. And that's it.
The big thing that the courts will get into, whether it's real property, which is what we're really looking at here, or even personal property, is opinion versus fact. And so sales people, along with the help of their attorneys, can really craft something that sounds like fact that's just opinion. The greatest show on earth for Ringling Brothers and Barnum and Bailey. The greatest show on earth, you know, it's a great show. It's not better than the Lakers, but it is a great show. And so you have to be, they're walking a really fine line when you're doing sales between opinion and fact. What are you representing as fact? You represented that, yeah, there was a window that had leaked, but we fixed it. It's not a problem anymore. Well, the roof is collapsing, and now the first floor is flooded. He skipped all of that information. And so when you're selling real property, there are obviously laws that apply that you have to disclose any material defects in the property. Foundations, roofs, floorboards, ceiling joists, things that are good in structural soundness. Most states have passed significant legislation requiring you to disclose anything that's wrong with the house that you know about or even that you should know about. And so in Johnson versus Davis, obviously it is a really brutal case of cover-up where the misrepresentation is significant and there's a fraudulent non-disclosure as well. It was a window that was leaking and that's wallpaper glue and really the ceiling is leaking. And I don't know if any of you have or have not been to Florida or at least the deep south, but the rain there is torrential when it comes in. You can get an inch or two in 10 or 15 minutes. You know, it may only rain, it may be sunny, it may only rain for 15 or 20 minutes, but you still may get an inch or two. So, gotta keep that in mind. Susan Redding's question, is the duty to disclose limited to just a real estate transaction, or could it apply to other chattel? There's going to be, obviously, there's regulations related to real estate, but there will be regulations relating to large ticket items like cars in particular. There's going to be obligations to disclose things that are not safe. So if you have a car that the brakes don't work, the steering locks up and it suddenly takes a severe left turn, things like that, yes, that's probably going to be legislatively created. So, yeah. All right. Any other questions, comments, concerns about any of our 4 cases this evening? Susan?
Thank you, Gene. I've sold like 5 homes, probably not as many as Maricela, but I've sold 5 homes, and I've always wondered if there's a time limit, like a practical time limit to when this disclosure no longer applies. Not to say that I've ever sold a home that I thought had an issue, but is there a time limit to being held liable for that type of stuff?
I have no idea. None. You know, statute of limitations are tripped a number of different ways. There's date of discovery, date of injury, date, you know, there's all kinds of possibilities. A date from the sale of the goods or sale of the real estate. There's all kinds of possibilities that can trigger the statute of limitations and get it running. I worked as an attorney when I was a young attorney right out of law school doing attorney malpractice defense, or as I like to say, the sharks defending the sharks. And the statute of limitations for attorneys is very short and very tight. And obviously it was written that way by attorneys to protect themselves, and supported by judges because they're attorneys to protect their colleagues. And so, you know, I can tell you a bunch about attorney malpractice statute of limitations, you know, which is a year from the date of the termination of the attorney-client relationship, the year from the date that you were on notice of the malpractice, you know, all kinds of ways that it can trip far before the lawsuit being lost. And so that is going to be true with real property and chattels as well. I don't know enough about that to give you a really good answer. And I'm sure that with a day or two of legal research, you'd be able to find a pretty decent answer relating to 1 or 2 subjects. But that's what legal research is about. Any other questions, comments, concerns before we call it a night? All right. Well, thank you to my 4 volunteers. That was just great. Thank you for your patience while we prepared for our presentation. And for me, totally regardless of the recording part, it was really fun to be back in class. Every time I get to sub, I realize how much I miss teaching. Not that I don't like being dean. Being dean's fine, but I got into this as a law professor and have transitioned out. So I hope to be back in class with you again at some point soon. I am not sure what the situation will be with Professor Visselman, whether he'll be here on Thursday or not, but don't worry, it'll be myself or Professor Visselman will be here. Have a good evening, everybody, and I hope to see you soon. Bye.